We're moving on to our third panel to consider property rights and how they are both treated in different legal regimes and how they evolve and how how things work or don't work as a matter of legal definition and institutional arrangements. I am uniquely unqualified to moderate this panel. My name is Ray Gifford. I'm a senior adjunct fellow here. I'm joined as panelist by Charles Howe, who's a professor of economics here. Retired.
Meredith.
Ramsey Croft, who's a water lawyer here in Denver or Boulder. And Karen Sheldon, who all three of them know something about water law. I will confess that my knowledge of water law consists of remembering the 2 or 3 lectures I heard as a first-year law student from my property professor, Richard Epstein, who will be speaking next and will tie all of this together, I'm sure, in a virtuoso performance. What we're going to structure this panel like is we want to start with the basics, assuming not everyone in here or many people in here like me are not water lawyers. And rather Karen is going to start by giving the concepts as they've evolved in water law, how the different water regimes work in the West and the East, and probably inevitably get to why water has to be treated in a slightly different way than any other good or commodity we know. So with that, Karen, I'll turn it over to you.
Great, thank you. It's very nice to see all of you. Thank you for sticking with this interesting conference. I've learned an awful lot that I didn't know about spectrum today. I suspect that many of you feel the same way. I feel some nerves about talking about water law with Charles Wilkinson and Larry McDonald and Rob Harris in the room, but we will go forward. And I'd actually like to start with a conversation about the ways in which water is different from the other 2 resources that we have considered this afternoon. I first would say at the outset that our panel is focusing on surface water. The law still largely differentiates between surface and groundwater, although Colorado is working mightily to integrate the 2. There are some similarities, and the more you think about it, maybe you see them, between spectrum and minerals. But there are more pronounced differences between those 2 and water. And it's the differences that really have led to and shaped the applicable legal doctrine and will continue to drive changes in our law and policy. And at the risk of stating the obvious, water is essential for all life. And that's the key distinguishing feature of it as a natural resource. And although it may come as a shock to some of you, the wireless spectrum and minerals are not essential for life. And this fact means that water has a significant and ongoing public value. It is regarded as a public trust resource, and there is tremendous public interest in its management. It also means that the range of users, those who depend on water, is much larger than those who use or have an interest in the wireless spectrum or minerals. And of course, those users include ecosystems, fish and wildlife, plants, and so on. Suffice it to say, those users do not need the wireless spectrum or minerals, but they do, in fact, need water. A second difference between the first 2 resources we looked at and water is that environmental changes, including climate change and drought, which we're very familiar with in this region, impact water supplies and uses of water in ways that do not affect the wireless spectrum and minerals. And these environmental changes present ongoing challenges to our water system of allocations and our legal and policy regime. And they're only going to get more pronounced as we experience increased drought and climate change, because they may affect everything, including water distribution patterns, the timing of availability of water, and so on. And so our system of rights and timing is going to be impacted. And a third difference between water and our system of allocation and the other two minerals, or other two resources we've talked about, is that we've seen a change in public values over the last century or so. In the view of the resource itself, what do we think about water? And this has and will continue to alter our concepts of rights and management approaches. I think we now see water more in the context of the environment in which it occurs. We see rivers as parts of landscapes. We recognize the value of ecosystem services. And we may conclude, and I think we are in many instances concluding, that those resources, those aspects of the resource are more important than our traditional, many of our traditional consumptive uses. We've also seen some changes in the use of water. The uses of water for mining, for irrigated agriculture, some of the early manufacturing and so on, have given way, and the rules and laws that grew out of those initial uses have given way to new uses. And even in this region, our major uses of water are urban uses of water. And as Charles pointed out, most of us don't hold water rights for the water that we use. We are customers of water utilities. We get our water from the tap, and someone else has the water rights that
Karen,
provides that.
Let me ask a basic question, if I may. How
Sure.
much water use in, say, Colorado is urban use versus agricultural use?
Colorado still has a fair amount of agricultural use, but across the West, agriculture is a diminishing part of water use, and I'm trying to remember the percentage, but it's something, Charles could
80%.
probably...
85% of consumptive use is still in ag in Colorado.
Right, but, and with our growing cities, and our changes in our demographics, that percentage is decreasing. And it's decreasing across the West in other states as well.
I'm sorry to interrupt you.
No, that's quite all right, but that is a balance. We still have irrigated agriculture as a major use of water, but we have increasing demands on the urban side that we have to meet. And we'll talk about this, I'm sure. Many people are looking at hungrily or thirstily, I should say, at farms as the source for water in the future. And we'll see what that means for continuing of farming communities and maintaining agriculture as a major industry in the state. And finally, unlike the thrilling days of yesteryear, we have very little unappropriated water in the state. Most of it has been appropriated, and we need to think very carefully about how we're going to use that water in the future. So against that backdrop of the essential differences that I see between water and the other two resources, let's talk about the key features of Western water law. To begin with, it is not an ownership doctrine. It's not your grandma's proverbial bundle of sticks. What you get with a water right is the right to use that water. It's that wonderful word, usufructuary. And the use of water is within the limits and conditions that are set by the state. The states are regarded as owning the water, i.e., they are the authority that determines the allocations and use of water. Now, we have two separate systems of water allocation in this country. In the East, where water is plentiful, the basic doctrine is the riparian doctrine, where the use of water is an incident of land ownership. If you own property on a water course, you have a right to make reasonable use of that water. And your right is correlative with every other owner on that water course. And it doesn't matter if you were the first user, the first property owner on the water body, or the 45th. Your rights are equal. And your rights are to make reasonable use. Reasonable use is a movable, changeable concept. And what is reasonable when there are only a few owners on a water body may not be reasonable at a later time when there are many more users. This doctrine leads to a great deal of uncertainty about the amount of water that can be used and for what purposes. That and some essential features of the West meant that it really was not a doctrine that could be applied readily west of the 100th meridian. Clear very early that the riparian doctrine was not going to work here. Let's start with the fact that we didn't have property owners with an incidence of water use in the West. Virtually all of the early users of water, miners and early settlers, were squatters on the public domain belonging to the federal government. And secondly, there's simply not enough water to go around in the West. Our water bodies and water courses are few and far between, and they don't exist always year-round. So we don't have as much perennial source of water as you do in the East. So we needed a system that would be reflective of the topographic, geologic, climatological circumstances, and also fit with the uses that people were making of the water to start with. And Charles talked about this. These rules grew up largely in the mining camps, where we needed something to substitute for hitting your neighboring claimant over the head with a shovel. And we developed a doctrine that we still have as our basic architecture today. 3 fundamental principles at work. Priority. First in time is first in right. Unlike the riparian system, we have a temporal system here in the West. Early users acquired senior rights. Essentially, having a temporal system provides a way to deal with shortage. In times of shortage, those who were there first, who have the more senior rights, are able to make use of water, even if the juniors go without. The harshness of that principle is moderated by limitations on changes in the rights by seniors, which cannot occur if there will be resulting injury to the juniors. Second basic principle is beneficial use. The right to use water for purposes that the state determines are beneficial. So you may think a use is beneficial, but if the state does not have it in its list of uses that are beneficial, you don't have the right to, you will not acquire a water right. Historically, beneficial uses were very limited, as Charles noted in the overview panel: mining, manufacturing, stock watering, and so on. In recent years, that concept has shown quite a bit of flexibility, and we've expanded the notion of beneficial use to include in-stream flows, water for fish and wildlife, and for recreation, which historically was not regarded as a beneficial use. Now, that has imposed some problems because those users, fish and wildlife, and even rafters and so on, are late to the party. They don't hold senior rights. They weren't part of the system initially, and that's one of the things that we struggle with in modernizing our water law today. The third element of the doctrine we've talked about throughout the afternoon, and that is the use it or lose it aspects. Water is too valuable to waste. It was also too valuable to hold on to when someone else needed it for a beneficial use. So the use it or lose it doctrine in the context of Western water really does reflect a value because of scarcity. The right depends on actual use. If you want to have a water right, you need to put it relatively immediately to beneficial use, or you may lose it. And your right is not perfected until it is applied to beneficial use. Today, we see that that is a double-edged sword, and from my standpoint, represents a significant disincentive to conservation, which is one of the most important ways that we're going to deal with our water limitations and make it possible to sustain our ecosystems as well as our traditional water users. We have two wonderful folks on the panel to talk about some of those issues. How do we work with the principles of prior appropriation in a West that is very different from the West that created this doctrine? I think one of the things that we will learn, and has surprised me over the years, is yes, you have a rigid architecture, but creative people and imaginative folks have seen ways to work around that architecture so that we're maintaining the basic principles, but dealing with the current demands. And looking into the future, we know that they're only going to be more pronounced. And so I was pleased that Charles used the magic words of environmental resources. I think it's important that we factor those in, because there are a lot of people with legitimate uses at the water body, but there are a lot of other aspects of our environment that need and demand that water as well. And I will stop there. And
Let me ask Charles to jump in here.
Charles.
The one on the panel.
Chuck, he's Charles.
Chuck. Well, Charles, you can jump in too. Chuck, and my take is a little bit simplistic, I admit, and I may not be able to encompass all of the values that Karen wants to see reflected in our water regime. But I'm begging for an economist's answer here, so let me ask my simplistic question. Many of the problems I see with our water property and water allocation system here seem to issue from not allowing the price system to work well enough and not allowing transferability to work easily enough. Am I just completely wrong about that, or how does an economist look at our water rights system and analyze it?
I guess I have to turn this thing on. Can you hear? Okay. Is it okay? You're partially right. You're partially wrong, right?
I hope that was.
The one thing that the minerals and spectrum people finally got around to talking about were markets. And it's true that a water right doesn't cost the claimant anything. That's the question of the initial establishment of the initial right. But the fact of the matter is that we do have active water markets. And these you're quite right that many of the prices, even the prices we pay in Boulder for our tap water, understate the full cost of bringing that water to us. And I can go into detail if you want. But when you have water markets, the participants of which are the large users, the cities, the industries, agriculture, that the market price of water brings to each of those sets of decision makers the real opportunity cost. I mean, what's being given up someplace in the state economy, let's say, by this use of water? Does the price that a user of CBT water pays the Northern District for water? It doesn't mean a thing. It's a small bookkeeping charge. It has nothing to do with the real value of water. But there are markets out there. I'll talk more about this, Ray, after a bit. But there are markets out there, especially the market in the Northern District, where they have very, very active water market for shares in the CBT water. Those prices are real. And let me tell you, a farmer who's considering the sixth irrigation of alfalfa, knowing that he or she could lease the water, if not sell the water right, pays attention to those market prices. The market prices for the major users overcome the defects of inappropriate pricing that we see and sometimes account for as the price of water.
And Ramsey, you're kind of there on the front lines and seeing how, in practice, our water rights scheme has applied. What's good about it, what's bad about it, and what has evolved? And Karen mentioned that we now are trying to account for a much broader sense of beneficial uses In the 19th century, it was, very let's settle, let's get the minerals out of the ground and make beer. We're good at that. But what?
We still make beer, I think.
Yeah. What's it like as someone who's doing this day in, day out, and how's the institutional arrangement in Colorado work or not work?
Well, that's a pretty easy question. I do have to think. I have an 18-year-old, and I would say that she would think her wireless device is more essential for her life than water. But leaving that aside, I guess my sense of the prior appropriation doctrine and how it works in the Western United States is that it does provide flexible ways. In different states, there's different models as well, and it comes a little bit to what Charles said earlier about in Colorado, we don't have any management of water, and there's some truth to that for sure. There's a kind of a local control type of overlay on water law, and it changes where you go.
And what are the local control? What are the relevant units for the uninitiated here? Are there water districts or regions? How is that water?
Yes. Well, so in Colorado, you have municipalities who seek water rights. You have a rancher who needs some water rights that may be adjacent to the municipality. You have somebody who wants to do a new biomass plant, and they will need some water to do their program to do their processing for energy. You have the fracking that's going on throughout Weld County and oil and gas development on the western slope, and all of those are looking for different water uses. Historically, we've had a lot of agricultural use. As Chuck said before, the 80 to 85% of the state's water has been used in agriculture. I think one of the overlays that you have to understand about water is that and conservation is while you use a lot of water, like when you take your shower and you use 20 gallons of water in that, most of it, 95% of that, goes right back into the system and then is used by somebody else. In fact, we're all drinking everybody else's shower water as we go along, except if you live high up in the mountains. But
on campus too.
Right.
It's true.
I mean, so there's that kind of reuse and reuse, not dissimilar really, I guess, to the spectrum in the communications world, where there's a gap somebody else can fill in and use, and you use that resource more than one time. I guess I wanted to speak to one piece of water rights that I think of in a practical way. When I went to law school here, I took water law from David Getchus, and he said, okay, there are 3 elements of a water right, which was music to my ears as a young law student. Okay, I can get that on a test. There's 3 elements. I need to divert. We need to intention to divert, the actual diversion, and then the beneficial use. And Karen spoke for a minute about beneficial use, and I think that also that body of law has a way of truthing water use over time. And it's not a fast way of reallocating the resource, but in fact, a lot of the work I do on a day-by-day basis is in augmentation plans and changes of water rights. So you use, and this is true all throughout Colorado. Major cities will secure some kind of agricultural rights, and they'll need to make a change. Well, if that agricultural senior water right from 1875 was decreed to irrigate 1,000 acres, and then in 2014, the city of Boulder goes to the water court and says, I want to use this water that's decreed to use it to irrigate 1,000 acres, the court and the state will force that new owner to look at what was actually used. And if that water right was used to irrigate 10 acres or 10 to 15 acres or 1,000 acres for 20 years, but then more like 20 acres for the next 50 years, they're forced to account for that less use. So that use it or lose it sort of principle comes in, and uses are ratcheted down as they go through this change process.
And is the use it or lose it principle, which we've talked about in various contexts through spectrum, through mineral law, is that a salutary aspect of our water law, or is it create some perverse incentives that are counterproductive?
Well, I think in the reform context, we think of use it or lose it as a way to avoid conservation. So if you think as a rancher that if you don't use all the water on your 100 acres and you only irrigate 20 acres, and you know if you change it or sell it to a developer or a city or something, you're going to lose down to that 20 acres, you have a perverse incentive to irrigate
Right.
more. From a practical matter, if you're a rancher and you're trying to make money and you have so much water, my sense is that you're going to use the water you have to do as much as you can with the money you have in the markets to sell what you've got and so forth. So I think academically it can be a perverse incentive. I'm not sure practically.
I think it's more academic than it is practical. In my experience, there's very little forfeiture of water rights. I just haven't been able to really see this as a major issue in the way we administer our water. That there are not many cases. I remember flippantly the case where one use was declared to be non-beneficial because they were drowning prairie dogs with water application, and that some court decided that was not beneficial. To whom, I don't know, but I just don't see the use it or lose it as an important issue in practical water administration in Colorado. And the market plays a role for this because, again, the farmer who's thinking about putting the 6th irrigation on alfalfa up here in Weld County is going to say, if I can lease this water for $500 an acre foot, what am I going to gain through the 6th irrigation of my alfalfa? A little more yield, but not very much. The market plays a big role in the water resources area.
Mm-hmm. Well, a couple of responses to that. A number of states, not Colorado, but a number of Western states are now have enacted legislation to allow water rights holders to hold conserved water. And that has been a tremendous incentive to them to conserve water, and then they have the ability to use it. In some instances, they have the ability to sell it or lease it or make alternate uses of it without the confines of going through the change of use system and so on. So I think that that's an important improvement, and I do see the use it or lose it doctrine working as a disincentive, because if you're going to spend, you're a farmer, and to conserve requires you to expend significant money to upgrade your irrigation system, so you're going to do that, and you might lose that water as a result. Why bother? There's, on the other side, there's no real incentive for you to conserve if it means that you're spending money that you're not going to recoup. And we need for our irrigated agriculture to be as efficient as possible, and that may mean some changes in the way that it is carried out. And if in the future our agriculture is less of an aspect of our economy, and there are other uses of water that become more paramount, we have to figure out how we're going to allocate the water that is currently allocated for that to other uses.
And Karen, of the states that have enacted this conservation proviso to their rights system, have they been in effect long enough that they've seen changes in use and better outcomes in some notional sense?
They're still fairly new. Montana is probably the oldest. Idaho has done it. California is figuring it out now.
I think.
And Oregon, yeah.
There's pending legislation in Colorado right now that seeks to allow farmers well, there's two different kinds of legislation. One is this flex water statute. So agricultural users could go through a change case and change their agricultural right to be used for flex uses. So they put it in a bowl and then they could sell it to a city for part of the time, or sell it to oil and gas, or do something else. I think there's some controversy. I'm not sure. I'm not close enough to the bill to know where it's going. But there's another bill, too, that is pending to allow you to box up your water rights and conserve, and then the amount of water that you do conserve, you can donate it only to the in-stream flow. And I would argue from the private sector, they would say, well, you know, if you're going to conserve water and not use that water, why can't you quantify that and sell it to somebody else or do something else with it rather than only being able to provide it to the in-stream flow? But it is an effort to incentivize people to be able to not lose their water right and use that incremental portion for in-stream flows.
If I remember correctly, Oregon has a sort of a mix of that you're allowed to take title to water you conserve, but 15% or 25% must be dedicated to in-stream flow. So you could have a mix of the way in which that water becomes used again.
So we talked on the previous panel about the real impediments, and they're really political economy impediments to treating the spectrum resource to its fullest extent. Spectrum law in 1959, Ronald Coase said we should auction spectrum. By the 1990s, we got around to thinking we might auction spectrum. In 2014, we finally have incentive auctions to finally get the broadcasters to perhaps chip in what is called beachfront spectrum in a mixed metaphor. Does water law suffer from the same kind of either incumbent bias issues or political economy issues that make a more efficient system more difficult to realize?
I don't think we're stuck with anything, Ray, in terms of the way we define property rights. I may come back to giving some illustrations of the definition of property rights, different kinds of water rights. But you know, as long as water allocation becomes flexible, the initial allocation, who gets it initially, whether you pay for it or not, becomes irrelevant as time passes. That with active mechanisms for changing the use patterns of existing water, and I'm thinking, of course, of markets, but there are other ways that water moves around too. As long as those mechanisms for changing the existing patterns of use are active, I don't think we're stuck on anything by virtue of having accepted priority doctrine in 1890 or whenever it was. That I think we have a flexible system, and I think both Ramsey and Karen mentioned if you look at the concept of beneficial use, are we stuck with beneficial use? No, we're not stuck with beneficial use. The concept has changed a great deal over time. So I see this system of priority doctrine as really quite flexible.
And so that's interesting to me, coming more from the spectrum world. Is that adaptability and suppleness in our water system because of the way we administer it through a series of courts? Is it that we think about it in common law ways where the rights are adaptable and tradable and evolve over time? Because I'm thinking in contrast to the FCC, who said, you know, here is your spectrum, you shall use it for this. If you want to use it differently, come back to us and we'll tell you whether you can or not. Is it a better institutional structure to adapt rights to a changing environment?
Well, to come back to what Charles said, this is Charles, not Chuck, but Charles, early on, that we don't have a management system. But in fact, we do have a flexible management system. We've got water courts. We can argue whether you want water courts or some other system administration. It's worked pretty well. It involves high transactions costs. But again, wherever I was going with that, we have courts, we have a state engineer, we have water markets that play the major role among those institutions, major role in the way we administer water. We monitor water use. We keep good records of water use. I understand other states that are a little laxer about in terms of not using the water court process still don't have the good records of water use that we maintain in the state of Colorado. So I think we've got a pretty doggone good management system, although it's not centralized. But the whole question of centralized administration of every resource worldwide has been moving towards decentralization to be able to differentiate among the different needs and desires of users.
And I'd
And
agree.
Ramsey, is that
We have,
decentralization, or what are the features that make it?
Well, I think
apparently-
we have a more iterative system, and in Colorado, you go through a court system. So you go, if you want a new water right, or if you want to change an existing water right, you go to the water court, where there's a judicial person who oversees you. 99% of those kind of cases go through in a very, in a settlement sort of process. You're not really in a courtroom doing the sort of plaintiff-defendant stuff that you see on TV, thank goodness for me. And, but you do go through a process with judicial oversight, which in our state I think has been seen as, you know, a fair arbiter of the water resource as someone's making an application. Arguably, you could say there has been a lot of rubber stamping by courts of applications for water rights over time. I'd say in our current legal world that there is no rubber stamp in our, there's higher and higher transaction costs to secure or change water rights as you go through a court system. Somebody earlier was talking about a 7-year trial for Spectrum with some disdain as I picked it up. I work in a water court case in Wyoming that was lodged in 1977. And so, you know, you want a long legal proceeding. That's the kind of legal proceedings that are out there in the water world.
Karen?
At the risk of not going along with all of this, I
Please
don't have,
don't.
you know,
We don't
quite
want
as,
people to go along.
as rosy a view of how flexible this system is and how it is managing to change and respond and so on. And yes, there has been some expansion of the concept of beneficial use. But we still, in the water law world, have tremendous resistance to change, to accommodating those uses that are not traditional. And there are rights holders with significant vested interests and money involved. And a lot of the concerns that
And what are the things that we're not taking into account, Karen?
that we in the system?
Yeah.
Well, one of the point that I wanted to make was that we have had the Endangered Species Act and other environmental statutes now add factors from a federal level to our state management of water and have forced recognition of some interests that probably would not have been recognized at the state level. And we still are pretty narrow when we try to accord rights to ecosystems or to fish and wildlife and so on. In Colorado, you know, our in-stream flow rights, which are administered by the Colorado Water Conservation Board, the amount of flow that can be retained in stream for fish is really fairly minimal. I'd like to see it be the full natural flow. We're struggling to change the operation of our water projects so that they more mimic the natural flow of rivers. We have not had the big conflicts over endangered species that they've had in other states, Oregon and California in particular, but those are huge and ongoing and will be exacerbated by the drought. So yes, when you look at how the principles of prior appropriation function reasonably well, there has been some change and some flexibility. But there are major ways in which the environmental aspects of water and the services that it provides are not being accommodated and those benefits not realized.
Chuck and Ramsey, would you agree that with Karen's contention that our system doesn't adequately incorporate the environmental issues or environmental concerns?
Yeah, well, I would agree with that. Again, though, I would point to our system as being somewhat iterative in nature. We didn't have an in-stream flow right until the 1970s, as Charles said this morning. Now we have in-stream flow water rights, which are very junior, except that if you're trying to change a more senior water right on a system, you have to account for that very junior in-stream flow water right. And the CWCB, Colorado Water Conservation Board, who holds those in-stream water rights in Colorado, they are involved in practically every water court case in the state. And it's because as you change a senior water right to a different use, we have what's called the no injury rule. So you're protecting from interference, right? The in-stream flow water right came into being at a certain time in the 70s or 80s, and they are, by law, entitled to the way that they found the stream. And so if you're going to change something around with your senior water right, which in other cases could call that junior water right out and not let the flow be there, then you now have to account for that. So for a town I represent, I change a historic agricultural water right and I move it to be used in a municipal plant. I have to make a deal with Colorado to say there's going to be at least this much water all the time. Now, like Karen said, I think those in-stream flows are not necessarily enough water for the natural systems, but
So
there's still some, it's the iterative process starts to take that into account.
A couple of things.
Yeah, absolutely.
Well, no, I think I agree that we haven't found a mechanism for adequate ecosystem, natural system protection. I don't think we can even float down our streams without hitting barbed wire across the stream these days, right? I don't know where that stands finally. So I think we do need to seriously consider other mechanisms for maintaining the natural environment.
And was the idea behind the Colorado Water Conservation Board and their role in all of these cases as a proxy for that interest?
No, I don't think so.
Well, I think there was public pressure to account in some ways for water for fish because our economy in Colorado relies on our natural resources. However, it's, from my perspective, that amount of water is, it's minimum amount for fish, and so there's a lot of criticism as to whether it's really adequate for natural resources. And so there's a tension. There are definitely streams in Colorado where senior water rights sweep the stream, and the junior in-stream flow is too junior, and so the stream bed for some portion goes completely dry, and fish aren't there.
They don't do well during.
So
Well,
they don't
Linda
evolve that fast. So it's kind of like your kid in high school. You can't wait for the school system to really change, right? So you pick the best school for them because they're going to school and they only have 4 years. So it's kind of like that. Can you wait for our streams to catch up and get better? Well, there's that tension, I think.
Chuck, you had a second point
Well, yeah, to somewhat different, not connected really to the environmental aspects of our water resources. But when we talk about property rights in water, we're talking about a bunch of different things, right? Mm-hmm. When we're talking about a traditional water right, a native water right to the traditional sort in Colorado, that water right is very unique. I mean, it has its own history. It has its own pattern of use. It has place and type of use. And so every traditional water right is unique. What's an implication of this? Well, one is that it becomes more difficult to run a market. A market for most things, homogeneous commodities, work very, very well. The grain markets in Chicago and all the rest. It's difficult to organize a really effective market in traditional water rights because then you do have to bring the courts and maybe the Water Conservation Board into the deal to evaluate what that right really stands for in terms of tradable water. If you, to a contrary case, very, very briefly, and we're going to run out of time, not water, but if you go up to the Northern District, go up to Berthoud, the headquarters of the Northern Colorado Water Conservancy District. Here you have a very effective water administration organization that administers the Colorado Big Thompson water that's brought over from the western slope. These shares in the Northern District, of which there are 310,000, but each share has a pro rata claim on whatever water the project is able to bring over in a given year. Every share is like every other share. There is no distinction. And furthermore, for somewhat special reasons, they avoid water court. When you change the shares in the Northern District, they don't have to go to water court. They do have to have approval of the board of the Northern Colorado Water Conservancy District. So there you get a very smooth working, almost continuous market. And the transactions are small because it's not very costly to change the use of 20 acre feet. Whereas when you look at the trading in traditional water rights, you get big, clunky, heavy transactions because the transactions costs are largely independent of the volume of water you're choosing.
So,
Trading.
so you have a contrast between what's a relatively uniform low transaction cost environment in the Northern District, whereas elsewhere in the state, because of the high transaction costs, you tend to get only larger transfers happening. Is that
That's correct.
essentially
That's
right?
correct.
That's accurate. But also, that while Northern runs like a well-oiled machine, you were wondering where my office was based, and I'm a wireless attorney. I'm based in Aspen, up in the mountains on the western slope, and I was born and raised in the western slope. So Northern is a well-oiled machine because it takes water out of the Colorado River and takes it to the Front Range, and none of that water, even if you use it in your shower and 95% of it goes back to the river, it goes back to the river on this side of the Continental Divide. And so from the perspective of an environmental resource on the other side of the hill, we have 4 endangered species of fish in the Colorado River, endangered because of the water withdrawals that go to this very efficient market mechanism that doesn't have to account for those externalities on the other side of the hill. So, you know, there's a tension.
Some of the reasons
Yeah.
are kind of
Yeah.
perverse.
Yeah.
We've got 10 minutes left, and so we're going to go to audience questions. Are there students first? And I don't know the students well enough, so we will
Be brave.
do away with that. Yes, sir, you in the back, and please wait for Dietrich to bring the mic.
Yeah, I'm a 1L. Just kidding. My question to the panel is, why don't we just get rid of use or lose it? I'm not hearing any argument that it's doing anything except impeding conservation.
Why don't we get rid of use it or lose it?
I'm in favor of it. I vote get rid of it. It doesn't really mean anything in on the ground administration.
Well, again, I think to me, use it or lose it in a practical way comes out in the beneficial use analysis, where somebody could claim a huge amount of water and use it for some period of time, and then is like the broadcaster, has a big hold on a big chunk of the resource, and the use it or lose it or beneficial use analysis is a place in the law that requires that use to come back down to something reasonable and what they're really using it for. So that would be sort of my answer. It's not like use it or lose it is really actually enshrined by statute. It's sort of a conceptual way to describe how beneficial use is handled. So.
Karen, would you get rid of use it or lose it?
Mr. Bramer, did you not read the assignment for today?
too. I couldn't do that.
The only reason to have use it or lose it at this point, I suspect, is to avoid speculation in water, to the extent that can happen. There are exceptions that do allow for cities and so on to acquire water rights before they actually need them and not put them to use until the future. But I think it's the biggest drag on conservation that there is. And that, coupled with the costs involved for agriculture and the constraints then on using that water in ways that are more beneficial to the environment, seems to me that it's outlived its utility.
Chuck?
Well, just briefly, as long as we have active water markets, the realization by the water user of the real opportunity cost of that water, it overcomes the issues, the motivational issues that we see in this use it or lose it. This emphasizes, again, the importance of transactions costs. When people go to move water around, the transactions costs are everything to do with buyer and seller identification and going through the water courts and hiring the engineers and agronomists that are often required. The more we can bring those transactions costs down to a level where it's really necessary for bookkeeping and equity and so on, that we don't load extra barriers onto the transaction cost, we'll have a more effective utilization of the water markets, reflecting still equity to the users and their water rights.
To me, the difference between use it or lose it in the context of water and context of minerals is really important. And I see a real use and importance to retain use it or lose it in the minerals context to prevent lockup of mineral resources by lessees that just hang on to leases and are able to continue them for forever and ever. And it's good for there to be a specific period of time, and at the end of the lease period, unless the lease is producing and paying quantities, then that acreage becomes available. It's a fairly common practice across the West, as we probably all know, for leases to go on forever and ever and ever. And they're just buying time and watching the markets in the mineral, and those are public resources, as much as water is too.
Stephen?
Yeah, thank you. I represent wireless carriers. I'm interested in talking a little bit about what technology is being used in terms of efficiency, SCADA assistance, remote telemetry, and doing those kind of things. Everything that can talk a little bit about how I think it's a perfect marriage between a wireless carrier, which you're going to try to improve in terms of efficiencies and better utilization of water in terms of monitoring and doing those kind of things. Can you fair to comment on anything what's going on in that arena?
Sorry, what was the question again?
It's about how you're using technology today, wireless data telemetry, measuring of water systems, doing those kind of things from a SCADA system, those kind of things in terms of, are they being deployed throughout?
And if I could even broaden the question, which is, one of the things we've talked about is how rights that were initially spectrum, which was initially allocated and used very inefficiently because it was the best we could do.
Yeah.
It's now technology's made that much easier, and I think the question is technology changing the right system here, or is the transactive nature of water, solving that, and you can chop it up into smaller pieces because the technology makes it possible?
Oh,
Karen?
There are a number of cases that have raised this issue in terms of improvement in irrigation systems, for example. And where the courts have come down is that if the technology being used is acceptable in the community, if it represents basically what fellow irrigators or fellow users are using, then there is no requirement to update. So there's some drag on improvements in technology because the courts and the legislatures are reluctant to require users of water to expend a great deal of money in upgrading their systems. There's developed kind of informal practice if a senior user is making use of water in a way that is very inefficient. A junior may offer to pay for upgrades and in exchange have greater access to that water. So you're seeing some incentives there to make changes. In terms of the major water allocation facilities, dams and reservoirs and so on, a lot of those are pretty old and the technology is relatively outdated. There are now efforts to upgrade the technology being used in those facilities, but they are big in-place pieces of infrastructure, and it's a little hard to incorporate a lot of new approaches into those.
I think municipalities, though, are more and more dependent on that kind of technology. Like I had a client call me this week. They're trying to catch this industrial user who's using potable water instead of non-potable water, and we can do it by that meter that we have rolling every day, right, and telemetry. And we've required more and more of that to occur. Our state water quality board, when you do discharge permits, they'll require continuous monitoring. And so the technology that's out there to help in an ever-tightening system that is facing climate change and drought and growing populations like the West is, I think is helpful in helping us to manage on a more local control level the water resource. So I struggle with it because I think, okay, do we need all this information? Because it just makes everything more expensive in the transaction cost and the litigation and whatever you're doing. But on the other hand, it helps decision makers get to deals sooner or try to figure out ways to have more efficiencies and, for a certain amount of payment and provide more water to a stream. So.
Chuck, final word.
Okay, well, not the final word, certainly, but we have an extensive remote sensing system, right? Monitoring system for our streams in Colorado. In my 40 years or whatever in Colorado, we have gone from administration by minor stream, Boulder Creek, St. Vrain. There was no way that you could tell what the downstream impacts of that were going to be. Minor streams were administered by themselves. Now we administer the South Platte Basin as a whole, and you can be called out by a senior any place in the system, wherever you might be, if you're junior to that right. So we really have developed in the last 40 years anyway, a sophisticated administrative system that I think has made the priority system much more meaningful too and much more efficient.
Well, with that will be the last word. I want to thank our panel